All right, welcome to our Family Engagement in the Dependency System webinar. My name is Anthony Miller. I'm a circuit judge in the Second Judicial Circuit. I focus on dependency and family law. We will now go through our objectives for today's webinar. We will discuss the anatomy of a dependency case. We will learn the authority of the dependency court, also identify the purpose, goals, and principles of the dependency system, recognize key individuals and terms in dependency, and lastly, demonstrate an understanding of trauma-informed family engagement.
And so next we're going to have a little activity here with a word cloud, and I'll go ahead and I'll share my screen on that point. Let us know what words come to mind when you hear family engagement in the dependency system. Great. And then the bigger the word, the more that it's been chosen as a selection here. And so I see a lot of collaboration, teamwork, support, no judgment, removal. A lot of powerful words here. Advocating, hard to locate, involvement, services, strengths-based.
I like seeing reunification too and support.
Case plans. I see people popping up in the chat over here too. Caring, sharing, discussion.
Teach me to love again, services involvement, parenting classes.
Fantastic. And I definitely see popping up on this word cloud here. Some of the biggest words are collaboration, communication, family, partnership. Great. So we have a lot of great things popping up over there on that word cloud and in the chat here today. All right, well, let's continue on with our presentation.
Now that we've identified the profile of the individuals participating in the webinar, you may be asking, what is the dependency system? The dependency system is the process whereby a child without proper parental care requires state intervention, state action to provide and supervise care for that child through the court-ordered services and programs. The next series of slides, we will identify some of the key dependency terms, and there are many in this area. There are a lot of acronyms, so we really spelled out each of the terms, but also indicated the acronym so that you will know the reference term. The Department of Children and Families is referred to as DCF, which is the executive state agency responsible for enforcing Chapter 39 Florida statutes, and we will go in detail later in the webinar about that enforcement statute. Regarding child welfare, Child Protective Investigator, or CPI, investigates allegations of child abuse or neglect. A dependency case manager identifies and assesses client and family needs as a result of allegations of abuse or neglect. Foster care refers to that care provided to a child in foster family or boarding home, group home, agency boarding home, child care institution, or any combination. Caregiver refers to a parent, custodian, permanent guardian, adult household member, or any person responsible for a child's welfare. Continuing with some of the key terms in dependency, Interstate Compact on Placement of Children, referred to as ICPC, ensures the protection and services to Florida children who are placed across state lines with parents, relatives, or in foster care. Also, multidisciplinary team, referred to as MDT, is an integrated group of individuals that collaborate to reach a consensus on the most suitable out-of-home placement, educational placement, or other important life decision in the child's best interest. Early Childhood Court, also known as ECC, is a program that serves the needs of infants and toddlers in dependency court. A very common term, guardian ad litem, refers to a team of attorneys and child advocates appointed by the court to represent the child's best interest. Also, probable cause is the legal standard required by the dependency court to determine if a child should be sheltered due to alleged abuse, neglect, or abandonment. Continuing with some of our key dependency terms, a case plan refers to the court-approved plan that includes all the tasks, services a parent must substantially comply with to be reunited with a child, and also includes services that a child also is receiving. Purchase of services are those services purchased from a Department of Children and Families contracted provider on health on behalf of a child or parent in dependency. Therapeutic supervised visitation refers to child-parent visitation supervised by a professional therapist with the purpose of improving the relationship between the child and their parents. Random urinalysis refers to those drug tests, random drug tests to monitor a parent's compliance with case plan requirements and the requirement to avoid prohibited drugs. And domestic violence includes a wide range of activity related to violence, assault, including sexual assault, sexual battery, and other crimes resulting in physical injury or death of one family household member by another family household member. Also, adjudicatory hearings refers to those determinations whether or not the facts support allegations in dependency or termination of parental rights case. A disposition hearing indicates, well, let me start this one over. Adjudicatory hearing refers to those hearings to determine whether or not the facts support allegations in the dependency or termination of a parental rights case. A disposition hearing involves a determination by the court as to the appropriate protection, services, and placement for a child. Judicial reviews are those statutorily required court review of a dependency case at least every 6 months until the child's adopted or permanently placed. Manifest best interest refers to the consideration by the court when making decisions that affect a child's interests, such as permanency, placement, termination of parental rights. And termination of parental rights is a decision by a court based on clear and convincing evidence to sever a parent's legal relationship with a child, and also must be demonstrated through the manifest best interest of a child.
So I know we just went over a lot of key terms here, and there's a lot of dependency terms as well. And it would be great to hear you kind of speak about family engagement and what that means to you as far as the court system.
Yeah, and family engagement means so much to so many different people. I know a lot of the individuals on this Zoom this morning I've engaged with, and they've engaged with so many different families. But at the heart of family engagement is that interaction between professionals in the child welfare system, professionals in the court system, between them and family and individuals in the dependency system that results in effective outcomes for all parties. And so I try to look at my engagement. And sometimes the court is effective and sometimes the court is not effective. but we try to work to have engagement that leads to a positive outcome for the families.
And let me ask you a follow-up question. That was very helpful, Judge Miller. Why was this a topic that you wanted to speak to? Why is this engagement piece so important in your mind, having seen what you've seen?
Yeah, I think that a lot of it, just looking at the most prominent words in the clouds that you all identified: communication, partnership, teamwork. You get the sense that it takes so many different people working together to try to effectively engage parents. It's not just one person. It's not just the court system. It's not just the DCF workers. It's not just the guardian ad litem. It takes so many different people and so many touch points that are so important for these families to try to get them to thrive and overcome some of the challenges that they bring into the system when they connect with the system.
Mhm. Yeah, it's a complicated space that requires partnerships across so many agencies. And it sounds like you also are really valuing that caregiver and those family members are spoken with and are included in that process as well.
Yeah, and I think it helps us all to understand we all bring something to the table that can further the engagement in a positive way for the families, regardless of what we do.
Somebody just had put in the chat how much they appreciated you kind of getting the ABCs down, so that because there are so many terms. And there was a follow-up question as well. Is the judicial review a meeting, hearing, or a paper review?
Okay, yeah, we'll talk some more about judicial reviews, but it involves the review of actual paper, but it also is a hearing. So it's a hybrid of review of actual records. I'm reviewing most records electronically on the computer. And we also have a follow-up hearing in court where we discuss the issues.
Yeah, so multiple.
Yeah, well, a funny connection. When I first became the dependency judge, everybody was throwing out all these acronyms and I had to stop them. And I bet they were wondering, man, we have a judge who doesn't know all these acronyms. I'm like, I don't know them. I'm new to this system. And I try to have the attitude, the first person that connects with the dependency system, they're already overwhelmed. The children have probably been taken from them. They have all these strangers, and we got to demystify and use common language and explain things to them.
That is such an important point. You know, everyone's sort of used to throwing around those acronyms. You coming in with those fresh eyes, you really were able to take the perspective of the family members who also didn't know it and say, hey, let's slow down here and make sure that we're using common language so that people can be included in the discussion. Really important point. Thank you for clarifying that.
Next, we will explore the authority for dependency court. We will start with state police power. The 10th Amendment of the U.S. Constitution delegates powers to the federal government, and those not delegated to the federal government are reserved for the states. The doctrine of parents patriae doctrine refers to the power of the state to limit parental freedom and authority in order to protect a child's safety and welfare in a secure placement. In the governing statute, enforcement statute in Florida is Chapter 39 Florida statutes, which governs the dependency process in Florida. That statute, that chapter gives broad discretion to the court, the dependency court, to protect a child's best interest through judicial reviews, appointments of guardians, and attorney ad litems. It is the duty of the dependency court to ensure that a child's best interests are advanced. The next series of slides that we will explore together dive into the purpose and intent of Chapter 39 Florida statutes. In this chapter, the Florida legislature sets forth the laws that govern the child protection system in Florida. And that purpose intent includes the provision requiring the care, safety, and protection of children in a healthy environment that promotes social, emotional, and physical development. Also, it promotes the health and well-being of all children, designed to prevent child abuse, neglect, and abandonment, and also provide a child protection system that reflects a partnership between the department, DCF, other agencies, the courts, law enforcement agencies, service providers, and local community, and others. Continuing with the purpose and intent, the Florida legislature also provides that the child protection system should be sensitive to the social and cultural diversity of our state, provides procedures for the department to respond to child abuse reports, and preserves and strengthens the child's ties whenever possible, removing the child from parental custody only when necessary. Also, ensuring that the parent or legal custodian who has lost custody also assists the department in locating relatives suitable to serve as caregivers. Also, to ensure that permanent placement with the biological or adoptive family is achieved as soon as possible for every child in foster care, and that no child remains in foster care longer than 1 year. Further exploring the purpose and intent, the Florida legislature also enumerates that the department is to make every possible effort to place siblings in the foster care system in the same home, provide judicial and other procedures to ensure due process through which children, parents, and guardians and other interested parties receive fair hearings by a respectful and respected court, that authority and dignity of the courts are adequately protected, and also to ensure that children under the court's jurisdiction receive equal treatment. And the child protection system is designed to minimize disruption to children's education when removed from home, and should create and maintain an integrated prevention framework that enables local communities, state agencies, and organizations to collaborate to implement efficient and properly applied evidence-based child abuse prevention practices, to preserve and strengthen families who are caring for medically complex children, and to provide protective investigations that are conducted by trained persons in a complete, fair, timely, and consistent with Florida law. Also, Chapter 39 recognizes that, for the most part, most families desire to be competent caregivers and providers, that children achieve their greatest potential when families are able to support and nurture their growth and development. Some of the policy-based principles for prevention and intervention in the child protection system will be explored in this slide. The health and safety of children are a paramount concern. Also, prevention and intervention should engage families in constructive, supportive, non-adversarial relationships, which emphasizes the whole family engagement. That's the focus of our webinar. Also, prevention and intervention should intrude as little as possible into the life of the family, focus on clearly defined objectives and child safety. Now let's look at some of the protections for children that I outlined in Chapter 39 Florida statutes. The protection from abuse, abandonment, neglect, and exploitation, a permanent and stable home, adequate nutrition, shelter, and clothing, that a child's basic needs are met, effective treatment to address physical, social, emotional needs, access to sufficient supports and services for medically complex children. Also, equal opportunity access to quality and effective education, and also other protections, including the ability to contact their guardian ad litem or attorney ad litem.
System carries a lot of different roles and does a lot of different things. And I know that you see a lot of families come in with a lot of different needs. So what has kind of been some of the biggest needs that you see coming from the families that come through the system? And I open this up to you, Judge Miller, and everyone else here that's on this webinar today. What do you see that comes in that families need the most support with?
It's varied based on the family, but for the most parts, by the time it gets to me, a lot of times the parents just want to be heard. A lot of times they want an opportunity to express themselves, because especially if their child has been sheltered, they may be feeling a lot of guilt. You know, is the judge judging me? How does everybody view me? I'm not a bad parent. And they may just be overwhelmed with so many circumstances. So from the court, my perspective, a lot of times they just want to be heard. They want to express another side to, hey, judge, this is something I really want you to know about the situation.
It's interesting. I find it so interesting. We've got some great things in the chat here, but that you went to a very person-centered need. You know, because we often think about needs and we go, oh, they need this service and these resources. And that's a lot of what's in the chat, and it's true. But I really appreciate that you just went straight for the need to feel heard, you know, because I think when I saw that last slide and I saw the expectation of having a non-adversarial experience in the dependency court, yeah, that really stood out to me. And feeling heard is definitely, it's even further than non-adversarial. It's really that engagement piece, being able to feel like you're being heard in that process. Skylar, what are your thoughts?
Yeah, I'm seeing a lot of great things coming through the chat. I see parenting skills. I see mental health support, support with navigating the system in and of itself. Just some really great thing, therapy, understanding trauma and how that works with an individual and a family.
Here it says families could benefit from having an advocate to attend dependency court with them to explain legal terminology. Many parents don't understand what's being said in court, and they remain silent out of fear and embarrassment. It's a really, really good comment.
I think that therapeutic courts give a sense of a more roundtable discussion with all the parties, including the judge. I think that allots for more parents to be heard. I know that here in Broward County, we have therapeutic courts where the judge doesn't necessarily sit at the bench. They actually sit at the round table with all the parties and have therapeutic discussion in regards to the family and their services. So I think that opens up the dialogue a little bit better for most parents to be able to feel like they have a voice.
I really like that comment, because I've actually visited not other dependency courts, but it was a drug court where the judge got closer to the individuals rather than kind of being perched on high. And I think for Mr. Williams, that's a very effective comment, because I think more of that, especially in a therapeutic court, is a positive experience for the family.
They feel included. When they feel included, it can really have some impact, it sounds like. Excellent.
I have a question.
Please.
So in instances where the child is removed, right? I heard a couple key points. One is to like keep the children with a family member, and two, if possible, keep the children together, right? Is there like a process or a hierarchy, meaning like if the child removed from the mother, does the course automatically look at the father first? And what happens if it's multiple children with different fathers?
Yeah, I think that's a good question. I think ideally, if you have, for example, let's just say that the kids are removed from the father. and the mother and father are separate, or they may even be together, but the primary reason was for one parent. And ideally, you want to put them with the other parent. If you can have the key to safety placed there. I mean, that would be primary. And then if you can't, for whatever reason, let's say both parents are just not able to be safety planned with it, and the department determines that, and the court, reviews it and agrees, and they're sheltered from both parents, then you look for other family members, those aunts, uncles, godparents, or close related type people. I mean, because these are children, these children are already familiar with these people.
Mm-hmm.
So there's more trauma when you put them with strangers.
Yeah.
So if you can keep them with family, because hopefully this situation is more of a temporary situation, a cooling off period where the parents need to deal with some things, and you try to keep as much normalcy for those kids as you can.
Thankfully, some fathers will be willing to care for siblings as well, who are not their biological child. Keeping children together is definitely a plus. Another comment. We're finding extended family also have often the same similar issues. And I think that kind of speaks to that generational stuff too. Any other thoughts, Skylar?
No, I couldn't agree more. And I did see some other things through the chat too that kind of talk about that it can be really hard for families to take in multiple children, in the middle of the night, spur of the moment, when the system gets involved, and that can be a real barrier on some of these families too, and their relationships with one another. So I think it's so important to engage those families so early on and have the court shelter them with, support and engagement, so that for the long term, these families are still able to collaborate with one another, and the children feel secure and safe in the best way possible.
Yeah, and I think the court recognizes one of the comments from Ms. Hyatt, there are cases where there are multiple children in the family, like 47 children. It is extremely difficult to allocate a foster family that will take care of the siblings. So that's a good point, because sometimes it may be difficult, especially on a short term, to do it. But the court does have status conferences and other things that we kind of follow up with, and it may be some opportunities later on. Hopefully you can reunify all 7 children with their at least one parent. But the court does understand certain situations might be more difficult than others to accomplish that goal.
Something I'd like to add is, as a therapeutic foster home, we find that it's highly important to try to get that bio information, especially with working with bio parents, even if we are TPR'd, or working with an aunt or an uncle. And sometimes we don't get that information, even though some of these kids get a bad rep, such as I may get a kid that was potentially abusive or aggressive, but come to find out it was an environmental issue. And then sometimes working with somebody in the family, such as an aunt or an uncle, to try to find that child a permanent placement instead of keeping them in the system any longer than we can. But the biggest fight that we come into that is not getting all that information.
And I think that's a good point, Mr. Roach, about that communication is so important, about the biological connections. So I think that's a well-founded point.
Well, and that co-parenting really sets the stage for the future of that whole engagement process too. So I think that that's so important. Yeah, Judge Miller, thank you so much for your words of wisdom on these points, and we'll go ahead and we'll move forward with our next bit here in our presentation.
Hey, right before you do that, just everybody on the call know that we have quite a bit of time set aside at the end of this, good half an hour, where we'll be able to have lots of Q&A. So if you have burning questions, please know that we will have time for those also at the end.
That's a great reminder, Jed. Thank you.
And so to sum up the purpose, intent, and focus of Chapter 39 Florida statutes, the goal of dependency is safety and welfare of children, timely permanency. And the permanency goals in order of preference are reunification with parents. It's best when children are able to be in a safe environment with their own family. Adoption, if petition for termination of parental rights has been or will be filed. Thirdly, permanent guardianship. Child's current custodians become legal guardian. Permanent placement with a fit and willing relative. And lastly, placement in another planned living arrangement.
So in this next video that you all are about to watch, we're going to see a parent at court being reunified and talking to the court about that process for her. And so we hope you enjoy the video, and we'll get to discuss a little bit more after that video.
I had to step outside of the box and take my situation from growing up as a child. I grew up in foster care, and I had to realize that I know what my son needs me and he wants me in his life. And that alone was enough to keep my head above the water, to be able to dedicate myself to visit my child in the rain, get on the bus, do what I had to do to be able to get my child. I'm just right on the joint to complete the case plan and get my son back, and to feel gratitude of the court, to feel that gratitude for my success and to be here in this event, to actually feel the bundle of joy that I've been waiting to feel, to see the judge and say, hey, look, I do got my baby back and we love him being home, you know, and get my son back was everything, even more than what I dreamed, because I had him. He's still here being raised. He's just 1 year old, you know, so to be able to be in his life and see him grow up is a big thing. And, you know, parents, we need our kids and our kids need us. It's all about love. And if you love your kids and you love your family and your life and you love yourself and you know what you want in life, you'll set that goal to get that. And I wanted my child, and he's here, and we're family, and I love it.
That smile at the end of that video, that just says it all, doesn't it? Tell us why you want to include this video, Judge.
You know, it's as we're child care professionals, you all deal with a lot of different situations, and a lot of those situations are very negative, even causing some trauma to you all. You know, it was referred to as secondary trauma when you experience the trauma of other individuals. Healthcare professionals experience it, caregivers. And so it's always encouraging to also highlight those times when parents are able to be reunified with their children, which is one of the most exciting experiences that can occur in dependency.
I love that you said that, because everybody on this call, my guess is, has to really deal with some hard stuff. And you don't often get, you see some of the most difficult things in our community, and you don't often get those great moments. So when we do, we have to really grab them and hold them and appreciate them, because that's what it's all about at the end of the day, more moments like that.
I think it was beautiful that that parent was stepping up to talk about her accountability, to do what she needed to do to be able to get her child back. And I think a part of that engagement is when a parent can see that the system is advocating for them, they're taking every step they can, and they're actually rooting for them to be reunified with their children. Makes it a lot easier to, like she said, keep your head above water and keep doing the things you need to do to be reunified.
Yeah, such a great comment. Thank you for that. Really, really good to keep in mind. Someone else here on the chat. These are my favorite types of hearings. I think we need to celebrate reunification more, put a lot of emphasis on National Adoption Month in November, which we do too, and it's really important as well. But this comment says, yeah, National Reunification Month in June, I believe, often goes unrecognized despite it being one of our primary emphases in child welfare. So really good to keep in mind that piece too. I'm just kind of looking through some of the other chats here. You guys are just amazing in the comments you're putting in. And I do agree, some of the supports do, we do try to have lots of supports in the system, but some of them do often kind of come as barriers or things that have to be then navigated by that
Yeah.
government, and that can be stressful. Did you want to comment in on that, Judge?
Well, I was going to comment and emphasize one point. I see that Paige Nuremberg had responded to the question where Ms. Treadwell said, how much monitoring is done after reunification? Life is still hard, which is a very valid point, because you don't want them to cross this, point in, this barrier, and then all of a sudden you just drop them. In Florida, even after they get reunified, there's a 6-month period that they have to be monitored, and we have follow-up. We have some additional judicial reviews. And so after the 6 months, if they're still in a safe environment, then the court will close this case and then give up jurisdiction. But there is a 6-month period there that allows for that follow-up to try to get the family in the best position to not only experience unification, but also have success afterwards.
Yeah, and I think that goes back to building that long-term support system while they're actively involved with the court. And I saw someone through the comments just saying even like that co-parenting we were talking about earlier, and how important that plays for the long-term future too of that family and for the kids. Because it's somebody there that the parents can then also rely on and ask for support for outside of the court, because the court's not made to be in their life forever. Yeah, some great comments coming through.
Yeah, somebody from Arizona. Arizona has a family reunification day committee that works to recognize and celebrate our families that reunified in Maricopa County. I like that.
All right. Next, we will discuss individuals in dependency. We just saw a parent share the excitement and joy of reunification. And so parties include parents, children, the Department of Children and Families, the attorneys representing parents. Also, the next category is participants, which includes foster parents, custodians, healthcare providers, guardian ad litem volunteers, and other volunteers. And then the third category is the court system, includes the judge, the most important person in the judicial system, the judicial assistant, the clerk of court, and the deputy and bailiff charged with keeping the courthouse safe. So we've heard a lot about the dependency system. Now let's look at the anatomy of a dependency case. Normally, a dependency case will start with a report, an abuse report. Someone calls the Department of Children and Families hotline. So a report is made alleging abuse, neglect, or abandonment. The department then has to conduct an investigation. If those allegations are verified, the department may take custody of the children under an emergency shelter. The department will file a shelter petition with the court, and shelter hearings are held within 24 hours before a circuit judge with jurisdiction to hear the case. So after a shelter hearing is held, within 21 days after the shelter hearing, the department is required to file a dependency petition and serve that petition on the parents. At any stage after the shelter hearing, the parties may be ordered to go to mediation in an effort to resolve the issues, short of going forward with further litigation. If the parents continue to deny the dependency petition allegations, a dependency trial may eventually be set. If the allegations are determined to be egregious by the department, instead of a dependency petition, the department may file a termination of parental rights petition against a parent. Mediation is a very important part of the court system. Mediation describes a process where a neutral third party called a mediator acts to encourage and facilitate the resolution of a dispute between the parties. Mediation is informal, non-adversarial process. The goal of mediation is to help parties reach a mutually acceptable and voluntary agreement. In a mediation, every party doesn't necessarily get what they want, but they come to an agreed, acceptable resolution. The role of the mediator includes, but not limited to, assisting the parents in identifying issues, fostering joint problem solving, exploring settlement alternatives, and a mediator will help each side see the weaknesses and strengths of their case, so hopefully they can move toward a positive resolution.
All right, so we're coming up to our halfway point here today in our webinar presentation. So we're going to go ahead and take a short 5-minute break.
Can you say the word Zoom? Remote hearings here are the new norm. With the advent of the pandemic, there was a significant increase in the use of smart devices to participate in hearings. The Supreme Court has authorized continued use of remote hearings as authorized by the specific court. In the dependency arena, there are no jury trials. Since no jury is involved in dependency cases, remote proceedings are expected to continue, including for some non-jury trials. Therefore, the court will continue to engage families through effective use of technology such as remote hearings. I've noticed since the use of remote hearings, the participation has increased because of the inconvenience. So that's a plus. Now, the downside of some of that is I have to address casual behavior because people view I'm just on the phone rather than I'm actually in a courtroom. But I have to remind participants that this is the court of law. Even though you're participating by Zoom, you're expected to have proper behavior. And so I've kind of created a script that I read to participants to remind them of the seriousness of these proceedings, even though they are remote. Some court proceedings, especially evidentiary matters, may continue to be conducted in person or hybrid, meaning that some individuals may be here in person, but others may be remote. For example, a child may testify in a remote hearings if the allegations may be of alleged abuse or other behavior affecting a child. It may be more appropriate for that child to participate remotely, or an expert. To cut down on costs, parties may request the court to allow certain witnesses to appear remotely. As indicated in this slide, the COVID epidemic has led to increased use of court hearings conducted remotely. Also has led to what we've seen in our county, in our courtroom, is that there's greater increased participation by the parents. And that's a plus because the more that parents can engage in the dependency system, hopefully they can move closer toward the ultimate goal of reunification if possible.
Yeah, I think Zoom has really revolutionized court system and really changed all of our lives as we're all here today on Zoom. And I'm sure this isn't, for many of us, our first webinar Zoom presentation. And so Judge Miller, what has really kind of worked with the Zoom court, and how has that really changed the system?
As I indicated in the slide presentation, we have seen increased participation by parents. A lot of times professionals who are juggling, trying to transport kids here and there, they can pull out of a situation and just get on a phone call or Zoom setting. So the convenience of it has been a plus, but there are also some negatives. As I did indicate, I do have to remind people that they're not hanging out at the barbecue. Put a shirt on, put a blouse on, make sure we don't see you going to the restroom. Don't smoke, don't put on your makeup or groom yourself while you're dressed in the court. We've had to have these conversations, individuals just rolling out of bed, getting on Zoom. So it is, with any plus, there also have been some negatives, but we've worked through them.
Yeah, and I see very similar things popping up in the chat too, that it's really increased a lot of parent participation and engagement as well. And then also, how has that really impacted also, children coming to court and other family members?
Yeah, I think the downside for the court system is we don't get a chance to see the interaction in person as much when you bring people to court. So we used to have our mass docket where everybody would come down to the courtroom. all the parents, all the children, caseworkers, foster parents. So the plus of that was that you had those individuals there. The negative side of it is a lot of times in talking to the dependency attorneys, they reminded me, they said, Judge, you didn't experience it, what we experienced, which was a lot of children here for long hours, hungry. A lot of these children have special needs, people having to park their cars, coming to the courtroom, bringing in that many people could logistically be a challenge at times. And then sometimes people had no contact orders. And so it was not as beneficial having them in the same courtroom. But again, on Zoom, it's harder to see those, interactions where parent hugging, a parent, a child, or interacting with the child there in court. So like I said, some pluses and minuses.
Yeah, and if I remember correctly, Judge Miller, you were pretty much coming on into the dependency court system right around kind of the height of COVID and Zoom court. So that must have been a real change for you.
Yes, yeah, it was.
And I know we have a lot of providers on here today and a lot of case managers and attorneys too. And I'm sure you're all familiar with Zoom court and its ways as well. So thank you all for your comments today, and we'll go ahead and we'll move forward with the presentation.
Continuing with the anatomy of a dependency case, we will now discuss case plans. A parent may decide to complete a case plan without admitting or denying the allegations in a dependency petition. The case plan sets forth the services and treatments for the parents and the children, explains what parents must do to be reunified with their child. A case plan should involve input from all parties, including children, if the child is of sufficient age and intelligence. Also, parents have 1 year to complete a case plan. A parent must substantially comply with their case plan or face possible termination of their parental rights, which we will discuss later on in the webinar. Judicial reviews are also a very integral part of the dependency system. The court supervised reviews are held periodically throughout the life of the dependency case. In a judicial review, the court examines a parent's compliance with an approved case plan. The court may inquire into the placement of the child to ensure the safety and security of the placement. And I indicated earlier that we have judicial reviews, and we have those on a mass docket. So to give you an idea of the scope of the cases, a particular mass docket for judicial reviews for our court involves sometimes upwards of 40 cases in one day. So if you break that down, that normally averages about 10 minutes per case. So 10 minutes is not a lot of time on these cases. Therefore, the court always really reminds the parents, reminds the parties to focus on the very important issues that need to be addressed and resolved during a judicial review. During that judicial review, the court determines if the department has made reasonable efforts to provide timely services to children and parents. If the department has not put in purchase of services and referrals for services, then a parent cannot comply. Therefore, the court, will address issues such as barriers. Also, the court may address other issues during a judicial review related to parent, sibling visitation, alternate placements, permanency issues, and other issues affecting the child's best interests. Some of the typical case plan tasks include individual counseling, both for parents and also given the age of the child for the child. Also, parent behavior health assessment and the requirement to follow recommendations. Those are very important reports that help a parent understand, and also the court to understand the needs in a dependency case involving the parents and the child. Child parent psychotherapy. Also, other case plan tasks include the parenting classes to help a parent receive the necessary education to improve areas that need to be improved on in order for them to be reunified with their child. Domestic violence risk assessment. Unfortunately, a significant part of dependency cases do involve domestic violence. So it's very important that a risk assessment be completed to identify those triggers and areas that need to be addressed to remedy and resolve these domestic violence issues. Substance abuse evaluation and the requirement to follow recommendations may be part of a case plan. Also, too, consistent visitation is so important for family engagements for parents and children to have quality and frequent visitation. And especially, too, when children are very young, is very important. And the studies really bear out the need for parent and child interaction for the development of that child. It's important if the children are going to be reunified with the parents, that the parents have stable income and housing. Also, that they provide material support to their children. Time is of the essence with case plan compliance. Remember the main goals of dependency: safety and welfare of the child, and also timely permanency. So time is very important to establish permanency. We need to have these children put in safe homes, in safe placements. The legislature has indicated that a child should not be in the foster care more than 1 year. Unfortunately, we have children who are in foster care, much longer than 1 year. Parents must take action to comply with the case plan to achieve permanency within the shortest time period possible, but as I indicated, no later than 1 year after removal or adjudication of the child, including notifying the parties in the court of barriers to case plan compliance. We've indicated some of the common barriers to case plan compliance. Others include lack of or limited transportation. That's why regarding these remote hearings, a lot of parents can engage more frequently because they can get on their phone and connect with the court or other device versus trying to navigate transportation if they don't have any. Personal sickness or injury. At times cases when a person may have a medical issue that really creates a barrier to them to comply with their case plan. Disability, inadequate access to housing, also issues dealing with the relationship between them and their child. Sometimes children are unwilling to participate in visitation, therapeutic or family counseling. This does create a barrier. Sometimes a child who has been abused, neglected, or abandoned fear spending time with that parent. And so if a parent is required to do certain things in order to be reunified, but the child is unwilling, that does create a barrier that has to be worked through as they strive toward case plan compliance. Substantial compliance is the legal standard for parents. It means that the circumstances which cause the creation of the case plan, that the parent has significantly resolved those issues to the extent that the well-being and safety of the child would not be endangered if the child is returned to that person's care and custody. So therefore, if a parent does not substantially comply within a case plan within a year, then they're subject to termination of their parental rights. The termination of parental rights, I've heard it described as the death penalty for a parent. If you're a parent, imagine losing your right as a parent because of alleged behavior. Therefore, the court does really treat termination of parental rights petitions with significant care and consideration. These petitions are filed by the department, but may also be filed by the guardian ad litem or any person with knowledge of the allegations, who is informed of the allegations and believes that allegations are true. Unless the conduct is egregious, usually these termination of parental rights petitions are not filed until after a year from the date of shelter, again, to allow that parent to work on the things that led to the removal and to complete and to come into substantial compliance with a case plan. However, if the conduct is so egregious, the department may file an expedited petition and not be required to offer a case plan. So some examples of those egregious, alleged egregious behavior could be child molestation, extreme, other abuse by a parent that leads the department to file a expedited termination of parental rights. Now, 3 elements required for the court to terminate the parental rights of a parent are: first, clear and convincing evidence, that's the legal standard, that a person has violated a statutory ground for termination. And we will look at some of those statutory grounds that are laid out in statute a little later in the webinar. It's showing that termination is in the child's manifest best interest, and also termination is the least restrictive means to protect the child from harm. Now, as we look at the grounds for termination of parental rights, this is not an exhaustive list, but it includes some of the more familiar grounds the department may allege. And understand that it's the department's requirement to show by clear and convincing evidence that these grounds, one of these grounds, have been met. One ground may be the failure to substantially comply with the case plan. We talked about that earlier. Sometimes parents make the difficult choice to surrender their parental rights, and that can be a ground for the court to accept the surrender and to terminate the parent's rights based on their voluntary surrender. Allegations of abandonment, neglect, or abuse, or incarceration. If a parent is incarcerated, can't care for a child if you're incarcerated, especially during the majority of the child's life or a significant portion thereof. Egregious conduct, we discussed it earlier. Aggravated child abuse, other sexual abuse of a child placed in 3 or more times in out-of-home care. These are some of the grounds that the department may allege in a petition before the parent's rights are terminated. So even if the department satisfies the requirements and the court terminates the parental rights, the department also must demonstrate that it's in the manifest best interest. And the Florida legislature lays out several factors that the court must consider in determining whether or not termination of parental rights is in a child's manifest best interest. So that really shows you that the importance of that relationship between the state recognizes the importance of a relationship between a parent and a child, that before that relationship is severed, before we end it, that we want to go through a very important process to make sure that this is ultimately in the child's manifest best interest. Some of the factors that they consider, that the court will consider, is the existence of a relative or non-relative placement for the child. The court will hear testimony about the parent's ability to provide for the child's basic needs, including emotional and material needs. The court will also look at the emotional bond with the parent and what degree of harm would result in terminating the parental rights. The child's present, future mental and physical needs. And the court will inquire as to how long has this child remained in long-term foster care, or to any special needs that would make it difficult for this child if the parental rights are terminated to be adopted. The ability of the child to form a significant bond with the parental substitute. Court will look at, the child's preference. If the child is old enough and intelligent enough, the court wants to know what is the child's preference. Also, the court will consider and listen to the guardian ad litem's recommendation. Some of you on this webinar may have been called to testify in a dependency case. And here are some of the various individuals who have participated or potentially will participate in dependency hearings. Dependency case managers, very common for them to provide testimony. These are individuals who are on the front line, who are working with the parents and coordinating issues with the child. And so they have a lot of personal knowledge about the different aspects of a dependency case. Healthcare providers, these parents are meeting with individuals as healthcare providers as part of a case plan. So these healthcare providers can provide very valuable information and insight for the court. Caregivers who are taking care of these children. Experts, the court hears from experts very often. People who have special expertise who can give testimony about the case, and especially complex cases, because it's important that the court understands some of these issues. Family members are potential witnesses, and children. I hear from children very often in dependency court. The court, if you come down here and participate in a dependency hearing or the dependency proceeding, everyone will tell you that I get very excited when children are in court. I make it a special attention to talk with them, engage them. I normally will ask them whether or not they're doing their chores. And so I think that the individuals have started preparing them, says, hey, he's going to ask you, are you doing your chores at home? And also to parents, probably two of the most common and important witnesses in dependency proceedings, parents and children. Now, the court hears different types of evidence in these dependency hearings. Case plan compliance is very important. Remember, if before the court, before a parent's rights can be terminated, it must be shown that a parent has not come into substantial compliance with their case plan. So records of compliance are very important. If substance abuse evaluations and recommendations are required by the parent, the court will receive evidence about how have the parents been doing with random urinalysis tests. Communication. Dependency, when you're talking about family engagement, communications are a vital part of effective family engagement. So text messages, emails, verbal conversation, these types of evidence are also very important part of the evidence that the court receives. Medical records, expert testimony, as we discussed before, and other information like criminal records are very important aspects of evidence that the court must consider. Here we look at the burden of proof that's required, and normally the department 90% of the time is filing the termination of parental rights petition or dependency petition. And the legal standard for the court to grant a dependency petition, and basically the dependency petition is the department arguing that this family, the parents, the children need services and they need state intervention based on the allegations. The standard is preponderance of evidence or a greater weight of the evidence. And there's a higher burden, which makes sense in order before the court will grant a petition to terminate the parental rights of a parent. Clear and convincing evidence is required before the court can grant a parental rights termination petition. So what happens if the department meets its burden and the court terminates the parental rights? Then the primary goal after that will be adoption. If the child is not adopted, the child will eventually age out of licensed care. Youth may remain in licensed care under the age of 21 under extended foster care if that is something that the child desires. And a lot of times that can be very effective for children as they transition out of licensed foster care into being young adults and trying to manage their life after the termination of parental rights.
So this next video that we're going to play for you will look a little bit about the post-TPR situation and what that looks like with family engagement in the adoption setting.
Yesterday, an emotional day for families as Leon County recognizes National Adoption Day. Parents signing the papers to become a forever family. Stacey Inez was lucky enough to be there and shares it was truly an emotional morning.
Emily Buckley can now say her foster care twins, Jack and Kira, will be with her forever.
And I'll no longer have the anxiety that is foster care of what's going to happen next.
In a Leon County courtroom with a judge presiding, she was legally bonded to her kids today, National Adoption Day. The twins are now 2, and she's been their caregiver since they were just 4 days old.
When you finally get to Adoption Day, there's very mixed feelings. You're sad because you know that in order for you to have this happiness, someone else has to go through a tragedy, but you're also just so happy to know that you get to have forever plans.
Another family celebrating today, Christina and Jeanette. They're officially adding Emma Catherine to their family, and she has 3 older brothers by her side.
We get to mold her into a beautiful young lady, and she gets to be with her brothers, her 3 brothers, forever. And the boys are so excited that they get to have a sister.
They fostered 39 children during the past 8 years, and Emma makes their 4th adoption.
It's been a long journey. It's been ups and downs and hopes and prayers, and to get the news that we could keep her forever was the most amazing day of our lives. We cried because it is truly a journey and it's a process, and there's a lot of grief and a lot of love and a lot of just emotions, but today we all just get to be together and celebrate everybody's families.
Both families say it feels like a weight has finally been lifted now that signing is complete. They say they hope to bring more awareness to the foster care system and how many foster parents are needed.
As you can see, adoptions are full of smiles, tears, love. At adoptions, we celebrate. As the video shows, each child has a special coin that the court gives them. It says, you're chosen, you're loved, you're adopted. And a lot of times we see some hard things in dependency court, but adoptions really are incredible because they're full of hope. And for a child who's gone through a challenging situation, they have a new family, a new opportunity, and it's something that I can't describe in words when you experience and participate in an adoption. And it's so also important that as we kind of discuss trauma and family engagement, so important to understand that a lot of these children in dependency, a lot of the parents and individuals, they've gone through a lot of trauma.
Yeah, so Judge Miller, what came to mind while you were watching that video?
Just enjoying the moment, reliving the moment. That was a special day. That was one of several adoptions in recognition of National Adoption Day that were done here in our circuit. I think we had 11 adoptions that impacted 15 different children. So 11 families were forever changed with a forever child. So I have nothing but just warm feelings about that moment.
Yeah, and I see in the chat too, some people commenting mixed emotions, and then adoptions and reunifications get me every time. I see that from Judge Shorstrom in here. Yeah, and that was a beautiful video, Judge Miller, and we're very fortunate you were able to be a part of that day to celebrate that in person. It must have been really powerful.
Yeah, and I appreciate the chief, Scherstrom, because he's been a mentor to me. He's the reason that I am doing dependency court. He approached me when I was in a different assignment and asked if I would be willing to accept the dependency assignment. I didn't know much about it, but after I looked into it, thought about it, discussed it with my family, prayed about it, I felt like it was a great match. And so I'm grateful that I've had this opportunity to serve in dependency court.
There's another
Judge Miller
question.
does not need a mentor, in my opinion.
I beg to differ.
And I thank you for letting me be with you today. Judge Miller, always a pleasure. I'm gonna turn my camera back off again. I'm so enjoying this, and you've been such a wonderful colleague, and make such a good point of how hard this is, and because you want to support the parents and the foster parents and reunification and adoption. This is so hard to be a neutral, and Judge Miller does it with such grace. I've learned a lot from you today and every day.
You're too kind, Chief.
We do have one question, Judge. Do you encourage foster parents to participate and speak in the hearings?
Yes, foster parents, they should have been included on the witness list that I included. They are frequent participants in our proceedings, dependency proceedings, judicial reviews. They are just a backbone to the dependency system. They testify in court. And so I encourage them, but they are active participants without encouragement one way or another, because they are invested in this process.
Yeah, and anyone else that would like to comment about, what words came up for you as you watched that video? And I know we had some people commenting too about it making them smile, mixed emotions.
I don't have a comment, but I do have a question for the judge, if you don't mind. I'm wondering,
Yes.
at what age do you consider appropriate to speak to the child? And when you do that privately? Do you do it with the other teens around?
That's a good question. I normally allow the child to guide the process of, when they want to talk to me. I'm willing to talk to any child. Now, age, it depends on their maturity. Normally, the children that want to talk to me are generally between the ages of 7 and older. I think the youngest child I've spoken to may have been about 7 or 8 years old. But what I normally do, somebody say, "Hey, Judge, a child wants to talk to you." And I say, "Okay, they are a part of this process by statute. They can come to every hearing. They can participate." Then I ask, do they want to speak to me alone, or do they want other people there? So I let them guide the process. And so some have said, "I just want to talk to you alone." Others have said, "I want this particular person who they may have a significant relationship with to be in that meeting." And so it varies, but I've had great connections with children in the dependency system. I think one question that is connected to your question, I think someone asked to share examples of discussions I've had with children related to maybe they didn't want to participate originally with the parents in visitation. We recently had a very tremendous case where the child wanted to talk to me, and I think I may have initiated the conversation because the child did not want to participate in in therapy with the parent. Parent had abused the child, and the child did not want to participate. And I said, "Well, let me talk to the child, just encourage, listen, hear that child out." So that after talking to the child, they had said, "Okay, I think I'm gonna give it a try." And I kind of helped them to see it's going to be safe. It's going to be other people there with you and the parent. And then about 5 minutes later, they said, "Okay, Judge, I want to talk to you again." And the child changed change her mind. And so later on, as the case progressed, the child eventually got into therapy with the parent. And now the child wants to be reunified with the parent. So that's an example of not forcing the child, but listening to the child, understanding their concerns, and not putting undue pressure on them. It was just a incredible change for me, and everybody who's participated in that case was very encouraged by the development and change.
That's so amazing, Judge Miller. And I just want to go ahead and let you know, there've been some great comments too, just giving you some praise. I absolutely love being in Judge Miller's courtroom. I love the way he interacts with the families and the caregivers. Judge Miller is wonderful at engaging youth and giving them an opportunity to speak. And just a lot of people in agreement with that.
Well, thank you for your kind words, but I tell you, it's a lot of room for improvement.
Well, I'll read just a couple more here as I see them, and then we'll move on into our presentation. And I appreciate Judge Miller and his patience. There's so much work, or there's so much behind the scenes work that goes on in preparing for National Adoption Day, and being able to make it all happen for these families is very heartwarming.
A very important part of dependency cases and dependency court system is trying to understand trauma as we engage families. It's important that we understand what is trauma. Try to identify those adverse childhood experiences that children in dependency have dealt with, and also to try to be more trauma informed in our communications as we engage families. And most of us have experienced some level of trauma. The degree of trauma may be different for every individual, but trauma refers to an emotional response to a terrible event, such as an accident, assault, or loss. And again, these are aspects that most of us have dealt with and continue to deal with. Too often, the children in dependency and parents, they have gone through a level of trauma a lot of times that's even greater than a lot of us even imagine. Some of you have heard of adverse childhood experiences called ACEs. The ACE study was a groundbreaking research project that demonstrated a connection between childhood trauma and adult health problems, such as chronic illness, mental health, and behavioral health issues. So as we engage families in the dependency system, it's important that we understand the impact of adverse childhood experiences. Some of the data from 2011, 2014, some of the data indicates that almost 2/3 of the US adult population reported having at least one adverse childhood experience, and 25% reported having 3 or more. And the impact of that is that since ACEs have been linked to risky behaviors, psychological issues, serious illness, and the leading causes of death, it's important that we understand that if we're dealing with individuals whose ACE numbers are very high, then we're going to be dealing with and trying to help them deal with and manage certain risky behaviors. Also, people with 6 or more ACEs die 20 years earlier on average than those without ACEs. So as we bridge the gap between understanding adverse childhood experiences that impact parents, that impact children, it's important that we lay important foundation for trauma-informed communication, meaning that the more we're able to communicate and engage families in a way that recognizes their trauma or minimizes it, we can be effective as we engage families in this child protection system. I think it's important to ask open-ended questions. A lot of times in court, recently I had a child in court who was very upset about the child protection system. They had aged out, and they wanted me to understand how problematic it was for them. So for about 10 minutes, this child just vented. And after the child finished, I asked the child, I said, I'm going to have another hearing related to this case in about 3 weeks. I said, I'm going to set it for at this time, and then I'm going to leave enough time in case you want to talk to me more. So later when we had that hearing, that child was there. I asked them, I said, did you have anything else you wanted to express to the court? And the child said, no, I got a chance to express everything when I talked to you last time. But I try to ask those open-ended questions. And again, a lot of times we may not have as much time in a particular hearing, but always leaving an opportunity for them to be able to open up and share. It's important to be an active listener. Also to understand and not accuse. Patience is very important. And also, it's always important to assume the worst. Give individuals the benefit of the doubt, not judge them based on previous conversations or previous actions, but try to have a more of a positive outlook when you're dealing with them. Here we've listed some of the examples of trauma-informed engagement. Again, the notion of these open-ended questions, I think is important when you're engaging families to try to ask questions to really communicate to them that you're trying to understand them. What happened to you? And allow them to express that. What do you think? Please help me understand your situation. If you start off by saying, I understand what you're going through, probably will shut them down versus help me understand. Part of active listening, sometimes if they express themselves, you can say, it sounds like you're saying that you want the department to better do this and do this and do this. Is that correct? And then they can say, yes, that's what I'm saying. Or they can say, well, that's part of what I'm saying, but it's another aspect. I see that you're upset. How can I help you? And these kind of open-ended questions, and these are just typical examples. Other examples can be used as well. Again, the whole goal is try to engage families, draw them out, try to understand, and see that it's not us against them. A lot of times they view the department or the court system or people in the system as enemies. And to the extent that you can dial that back and engage the families, the more effective you can be to try to reach the ultimate goal of dependency, which is safe and welfare for the child, timely permanency. All right, we have some don'ts. Please do not talk down to families. This dependency system has a lot of acronyms. I remember when I first started as a judge, they were like the PBHA and the DVR, and I had to say, slow down. I do not know what you all are talking about. And so I try to stop that conversation because I put myself in the shoes of somebody. If my child was taken in the middle of the night in the arms of the state, in the foster care system, I don't know who has my child. Here's a Zoom number, 8:30 in the morning is the hearing. You get on the Zoom, you have all these strangers, you wonder where your child is. I try to put myself in that type of, in the shoes of somebody like that. And all of a sudden you get on the Zoom and people are talking a whole different language and they're using all these acronyms. To avoid that, I have strongly encouraged our professionals, stop yourself, explain what you're saying to people. And I think that's helped increase the family engagement, hopefully, in the court system. Don't be judgmental. A lot of times you may get frustrated with a particular individual, but showing that frustration does not increase family engagement. Patience is very important, as we talked about. Also, too, if a parent requests something, timely respond. Or if you don't know the answer, hey, I will get back to you. And then follow through when you promise them you're going to get back to them. And, you know, as a professional, when you don't apply principles of being patient, when we're not really communicating and explaining things to people in dependency court, what happens is that it leads to a frustration level. I've been in hearings, you know, on Zoom where the parent participating is upset to the point where it's hard to communicate with them. That I have to allow them to kind of calm down, then ask them, could you kind of explain, you know, what's wrong? A lot of times it will be connected to someone not explaining things to them, you know, talking down to them or treating them in a way that they did not feel like they were being heard. That's why it's so important that we, you know, practice and apply these principles when we're engaging families. That's why it's so important. I'm not going to sing Aretha Franklin's R.E.S.P.C.T., but so important that we provide families respect and dignity. You know, the other day I was talking to a child, and they wanted to talk to me privately, and we were put in a breakout Zoom room. It was just the two of us, and they had gone through the dependency system, and they were close to being aged out. And that child looked at me and says, I just want people to treat me as a human. And that stood out to me. Families and children in the dependency system are going through some tough challenges. Some are escaping domestic violence. Some parents, given their situation, may be faced with the decision to surrender their parental rights. We don't have to agree with the parents' choices, but it's important that we show respect and we do display that level of humanity. You know, most of us have heard of the golden rule: treat people as if you want to be treated. Treat them with humanity and dignity. And it's important that you talk about them and you talk to them, not about them as if they're not in the room. And that's why strength-based communications are important. We all have weaknesses and strengths. As obvious in the dependency system, parents, children, they have weaknesses and they have strengths. Focus on the strengths without ignoring areas of improvement. One other aspect that's very important, I try to model this in the court system, is when the judge makes a mistake, when I make a mistake, I try to apologize right there in front of everybody. Because if I am trying to call everyone in the hearing to be respectful, it's important that I model that example. Model humility. If you make a mistake, you promise a parent you're going to do something, take ownership of it and just say, you know what, I apologize. How can I make it right? Or what can I do to move this case forward? What do you need from me? Those open-ended questions, invitation, they demonstrate respect and they further family engagement in the dependency system.
Great. So we've reached our Q&A part of today's presentation. And I did want to go back through some of those questions that have popped up along the way. And then if anyone else has any new questions or new thoughts, please feel free to put them in the comment chat box or unmute yourself. We'd love to hear from you. So I know, Judge Miller, one of the things you had mentioned too was the case plan and the time frame for permanency. I saw through the chat, if the case plan was enforced, you know, wouldn't it reduce the time to permanency greatly?
Yes, I would agree with that.
Okay, and so what are some of the supports that are extended to caregivers, informal caregivers, or formal supports rather, as opposed to some of the parents in the system? What supports do they receive?
Yeah, the general question is a couple asking about aunts, grandparents, informal family supports. Do they receive the same formal legal supports as biological parents?
Oh, like appointed attorneys?
Just the supports that a biological parent gets, do informal supports, informal caregivers get the same options?
I'm not as familiar with all the details about what supports all the other individuals get. I mean, that may be more of a DCF question, but if they are I can't answer this. I can answer it like this. So we have a lot of different individuals who come into the court system who are supporting these families. I try to recognize them and ask them, you know, based on their engagement, what are some of the things that you're seeing? What do you want to express to the court? So from the court perspective, I try to give them an opportunity to express themselves in court while recognizing I can't hear from everybody involved with this family, because generally I'm limited to about 10 minutes on a judicial review. But to the extent that I'm able to hear them, but if they're providing support to the family, a lot of times the guardian ad litem will be reaching out. If they're helping provide care, the department case managers reaching out to them. So a lot of different people, a lot of different touch points for these families. But I do try to hear them, because sometimes they will provide information that's relevant to what I need to decide to. As a judge, I don't micromanage all the details of these individuals' lives. I'm not like the guy on the Wizard of Oz behind the curtain, you know, really controlling everything. That I'm like a referee in a sporting event. You think about a referee in a basketball game or a football game, and I don't control which plays the coaches call. And so I'm limited to what I have. You know, part of being a judge is you have authority, but you have limitations on that authority. So I'm not micromanaging the lives of these individuals.
Great. And then I did see something come through as well, just a little bit about notice of hearings for foster parents, and how can the court kind of help assist that to be more timely, or if there's any feedback that you have on that, Judge Miller?
Well, if somebody's complaining they're not getting notice, you know, that's something I will address. But again, because the sheer number of foster parents, I don't personally monitor who all is getting notified. I mean, I do rely upon individuals who connected with them to share individual, you know, this hearing is this date and on this date. And generally I've seen in our circuit done pretty well, or if they're not getting information, the department normally will address it. But if it's an issue, they have come to court and say, hey, Judge, you know, I didn't know about this, or I know about this, especially if they have participant status, which is they can request participant status, and I, you know, per the, you know, pursuant to Florida law.
Yeah, and we just got a question coming through the chat. Do you prefer foster parents to be in your courtroom?
Like in person?
I believe it's in general. Do you like them to be present at court?
I like everybody to be present at court, because again, you being present at court doesn't mean you get a chance to come to court and spend 10, 15 minutes, you know, expressing yourself, because I have limited time. But I have seen caregivers provide written reports to the court. And I try to be understanding that a lot of these foster parents, they're not attorneys. They have frustrations. And so sometimes when they express themselves in court, it can get into a back and forth, because they will say something that will trigger the parent. Well, I didn't do that. You said this. And they kind of go back and forth, which is not the best use of court time. So I normally say, I respect both of you all to the extent that you can discuss it outside of court with the dependency case manager, guardian ad litem, other individuals. If you can't resolve it, these attorneys, they have motions that they can file, and we can put it on a special hearing so I can hear the arguments, because everybody doesn't understand how court works, and they don't realize that I can't hear everything at a judicial review. And sometimes I will special set or set it for a status. So, okay, that's the issue I need to discuss further. I'm gonna set it for a status, and I give the parties and the individuals involved 30 minutes, but I can't do it today.
Right. Trying to do what you can with the court's time. I'm sure that's a real juggling system you have to do. Some days.
One thing, sometimes the judge has to tell you no, and it happens, and it's okay for people to get frustrated, because sometimes they get frustrated with court, dependency case manager or department or the guardian ad litem. I don't mind being a bad guy. That's not my goal, but sometimes you have to kind of let people know where the boundaries are, but we can set it for another day to try to hear the issue.
Judge Miller, I got a question for you, because I was going to ask the question about having foster parents in your courtroom. My question to you, would it be beneficial for a guideline to be set up for how foster parents should be in a courtroom, such as you provide just the facts, no emotions, something like that, that maybe they could be passed out to everybody, so everybody is on a set standard across the state?
Yeah. I'm not for set standards for everything, because the Second Judicial Circuit may be different from how things are managed in another circuit. In some circuits, dependency court, that's all the dependency judge does. In our circuit, I have dependency court, but I also have family law cases, and I have domestic violence injunctions. And so how another circuit where the dependency judge, that's all he does, that might, he or she, that might be totally different. So I'm not for establishing some national or statewide standard. I see what you're saying, but I generally just address the particular cases, and I try to set a tone consistently with each case that comes before me as to how I handle it.
Thank you for your insight, Judge Miller.
Okay.
We've had a lot of great conversations coming up in the chat too, with information across the board for everybody who's been kind of asking questions along the way too. Some really great information. And I know we're kind of wrapping up on time here, but if anyone has any burning questions or even just, oh, go ahead, Judge.
Well, there was one question about conditions of return and also the reunification. So that's a real good question. The short answer is, if a parent is in substantial compliance with the case plan, generally they are eligible or ready to be reunified. The department also has the safety analysis questions. A lot of times, for example, a parent's attorney, if they think the department is being unreasonable and has not reunified the child under the discretion given the court, they'll file a motion for reunification. And then these safety planning questions, and I'll go through them real quickly, is number one, is there willingness for an in-home safety plan to be developed and demonstrated that the parent will cooperate with? Home environment is calm and consistent enough for an in-home safety plan. Safety services are available at a sufficient level. The in-home safety resources can sufficiently manage impending danger without a professional evaluation. And the fifth question is, do they have a residence to implement an in-home safety plan? So if the evidence supports and the answer to all these questions ends up being yes, then the court will grant that motion for reunification. A lot of times, reunifications take place without a motion being filed, because the court is given discretion normally with agreement of the guardian ad litem in the department for reunification. And then if somebody's being unreasonable, a parent will file a motion and say, hey, judge, we met it, and they're just not being unreasonable. And I've granted some of those I've granted some of those motions. Other times I've denied them based on the evidence.
All right, well, thank you, Judge Miller. And well, before we wrap up, any other burning questions today, or any thoughts, or anything that you learned today that you liked, that you didn't know before? It has absolutely been great to hear from all of you today on this chat and for your participation.
Yeah, before you leave, I see Ms. Shanta Wilson with the Center for Health Equity. She comes to court a lot, and she has really been very beneficial to the Second Judicial Circuit and a lot of other professionals on this Zoom call. And we do appreciate all those partners who come and present and help, because this system is not a perfect system, and that's just the truth of it. But to the extent that we can continue to work together in a productive way, I think it benefits everyone involved, especially the parents and the children.
I'm just curious with the parents, and then as a clinician and providing and helping them to advocate for themselves. At times when they're in court, they don't really get a chance to talk. Is their attorney speaking? Is it possible, or is it encouraged to get them to write letters to write a letter to the judge, or to be put in their files so that they can express themselves?
Yeah, well, if they are represented by an attorney, I do encourage them to try to work first with the attorney, because sometimes parents may do things that can undermine kind of what the strategy they may have with the attorney regarding the case. But I have seen, it's a therapeutic kind of court, so I'm pretty flexible, even though they represent an attorney. If they want to say something, I will be open to it. Sometimes the attorney may say, I'm advising you that at this stage is not best for you to say anything. And so they can either listen to that advice or not. But at the end of the day, I would defer to them if they want to express themselves to the court or write something to the court. But I do encourage them, if they have a representative attorney, that attorney is required pursuant to their representation and the regulation of the Florida bar that they are under, is to zealously represent that client and that client's best interests. So I'm respectful of the attorney-client relationship.
All right, well, I think Judge Miller will go ahead and we'll wrap it up here with one final question to you. What has been the most rewarding part for you while working in the dependency system?
I think for me is learning from the different individuals who have who are engaged in this system. I always tell people there's never a dull moment in dependency court. And I've had a lot of moments that have helped me to learn a lot about myself, helped me learn about the system. And I try to really have an open mind and look for opportunities to personally improve and try to improve the system where I can within the limitations that a judge has, because I don't have ultimate authority. Some people think that the judge just has like full authority. That's just not the way it works. But I have a lot of respect for the professionals on this Zoom call who engage in this system. And most of you all, I'm sure you're not motivated because this area doesn't pay the kind of money it should pay for the work that you do. And that's unfortunate. And we, as a state, we need to take place more value on the work that you do. And also, I really think that more pay should be associated with. But I know for you all value the families and value the difference you're making in the lives of these children. And I do encourage and very grateful for what I've learned from individuals like yourself involved in the system.
Well, and we here at FSU, thank you, Judge Miller, for your time with this presentation.